going to try to wing this without notes because mine are scribbled on, but I'm just going to kind of do a brain download for you of kind of what to expect from the Real Estate Commission and then kind of what's going on at the division as a whole. The good news is to my knowledge, DORA will not have any DORA bills that affect Division of Real Estate. I know that they're still working through the legislative proposals, but it doesn't look like any of real estate's came through. We didn't have anything pressing. There's like no emergencies as far as we're concerned. But on that note, I've been notified about the sunset review for the Real Estate Commission, and it's not just the Real Estate Commission, it's also the Division of Real Estate. So we will meet with our policy analyst on Friday, and that will kick off the sunset review of the Real Estate Commission. And essentially, they look for different criteria. I do not have it committed to memory, and that's part of the meeting that I get to go to on Friday. But they will look to see whether it's still necessary to regulate the real estate brokers, which I can tell you, I cannot fathom that they would say, no, they can self-police, it'll be fine. You guys are our largest group and our most active. And while most of the complaints result in a dismissal or maybe minor remedial action, we do have some glowing examples of probably people that shouldn't have been licensed as a real estate broker, but unfortunately, we don't have crystal balls in which to see the future. They come in, they meet the standards, and then we're here to deal with any issues that they cause. So they'll look to see if the brokers still need to be regulated. And typically, it also provides us with the opportunity to identify areas of growth or improvement for the regulatory program. And we've been kind of working on those over the past couple years in anticipation of sunset. So a couple of the things that are kind of on our mind to change is to slate you guys back to a December 31st renewal. That's to help you with the CE compliance issues that we've been seeing with the commission update course. So primarily what we've been seeing is that we've got people that take the update course religiously, which is good. Every year they take an update course. Well, because you're now on anniversary dates, you really have to be very careful about when you're taking that update course, because we have some that they take it every year, but unfortunately, one of those classes fell outside of the 3-year cycle, which then puts them in non-compliance with CE, and they get fined for it. So that is one thing that we're looking at. Another thing that we may discuss is, do we still do an update course? Do we have an alternative to that? You know, maybe the alternative is you guys have to take an annual course in contracts and you have to take a class in legal updates. Depending on which group of brokers we talk to, some will tell us, you know, that update course was of no benefit. I do commercial, I do agricultural. The update is really geared towards residential sales brokers. And if it's a residential sales broker, what I hear is, I'm sick of hearing about the property management issues. So we get kind of mixed reviews on the update course. So one of the things that we may consider doing is just an alternative to that. We've also been contemplating, and we put together 2 task forces to deal with the next 2 issues. Should the employing broker requirements be enhanced, meaning should there actually be an experience requirement instead of you're licensed for 2 years, you take the 24-hour broker admin course, we're going to send you out to now supervise other brokers and be responsible for them, even though you may not have done any deals in those 2 years. Or you may be supervising people in an area that you have no experience in. So that's one of the things we're looking at. And also, is there additional education that would be beneficial for the employing brokers? Instead of, you know, here's your trust accounts, these are the expectations of the employing broker, really kind of setting somebody up for success to supervise brokers. So that is on the employing broker side. We've got a task force looking at whether we should do a separate credential for property managers. They are the one kind of category of brokers that seem to constantly drive complaints down at the division. And their complaints, a lot of the times, have a monetary aspect because most sales brokers don't manage their own trust accounts. And frankly, if I was to go leave the division tomorrow and decide to practice real estate, I'd probably be a sales broker. I don't think I would opt for property management, just based on what I've seen. So if I was a sales broker, chances are I don't want to handle trust accounts. That's kind of an area of liability that I don't want to deal with. We have some that do, but there's a lot that opt that, I'm not going to, the title company can hold the money. I don't want to deal with that. Well, when you're dealing with property managers, they are holding the trust accounts, and we see issues with, the security deposits are being held properly. They have rental income coming in, and sometimes those funds are applied to other clients as opposed to the ones whose funds it should be. Or there are other times where we just flat out see theft, where the funds come in and they use it for their operating expenses. We've had people take vacations on other people's funds. So when we're looking at the property managers, some of the things that we're contemplating is they've got the same education requirements as a sales broker. It's the 168 hours, you pass the 2-part exam, and then you're good to go to practice whatever requires a real estate broker's license. Hopefully at this point they've chosen to take maybe a course specific in the practical applications that covers property management in the 168 hours. But I think a lot of people go through the broker education not really knowing kind of what arena they're going to fall into. So they could very easily have taken everything that is specific to kind of sales brokerage, and then they end up in the property management world. And it doesn't really set them up for success. And it does give us some employment insurance, because those are usually the ones that create a bunch of problems and then we get the complaints. But that's not really how we want to see things done. So we're kind of looking at, do we need to enhance their education? Should they have a separate credential? What do we do with them? And another thing that we're looking at with the property managers, based on the issues that we see on the enforcement side with trust accounts, is should it be written into the law to allow for receiverships, so that if we've got a broker that appears to be stealing from people and we take action to take away their license, that we can then take over those accounts so that they still don't have an avenue in which to commit theft. We've had a couple brokers where we've taken the license, we've taken their license, and we've taken the employing brokerage's license because they were the employing broker. But collection of rents is not a duty under the Practice Act that requires a real estate broker's license. So even though their license has been revoked, they have existing leases out there that they have continued to show up and collect rents from the tenants from, and they pocket those monies, so the theft is ongoing. So that has been an issue. So we may be suggesting a change in the statute to allow for receiverships. And it may be something where we further just fine-tune what the duties are when you're doing property management that require the real estate broker's license. Because right now, procuring tenants and negotiating leases, those are the license duties. So that's what we're looking at with Sunset for the property managers. We have not evaluated increasing pre-licensing education. I do know that the Real Estate Commission itself would like to see an increase in your continuing education requirements. They'd like to see it go from 8 hours annually to 15 hours. And I know that kind of the reasoning behind that is when you look at our 3 primary licensee types, the real estate brokers, appraisers, and mortgage loan originators, the real estate brokers have the lowest compliance rates with the CE requirements. You guys have been licensed since late 1920s, early 1930s, and typically what we see is you've got about an 82% compliance rate with your CE. The appraisers have 90% or better, and the mortgage loan originators are typically at 98, 99% compliance. They've got some federal assistance, though, with their licenses. If you're a mortgage broker, you've got to get licensed on 2 databases. There's the Federal National Mortgage Lending System, the NMLS. You have to go through their process before you can come to the state and get licensed. So when you go to renew your mortgage license, if you don't have your CE, NMLS won't let you renew, which means you can't come to us and then renew. So there's kind of those safeguards in place for the mortgage brokers. For the appraisers, we have federal regulators called the Appraisal Subcommittee. We call them the ASC. And they've got rules, and if we can't demonstrate that 90% or better of our sample audit is compliant with CE for the appraisers, then we have to change our process. And what we do with the appraisers is pretty typical with what we do with the real estate brokers. We have them attest to CE compliance at time of renewal. And then in February, because we allow them to attest to it, we have to do an audit sample, and that audit sample has to demonstrate 90% or better compliance with CE requirements. If we aren't able to demonstrate that, then what we have to look at is at renewal time, everybody has to go through a CE audit for the appraisers, which would be a management nightmare for the appraisers and also I think for staff. So we almost pick them up and drive them to their CE to make sure that we don't have to go through that. So then the brokers, you guys don't have that federal overlay, which I thoroughly appreciate, but you do run into the issue of 82%, 80, whatever it may be. Those are the compliance rates. So the commission has said, well, we think the compliance rates would increase if we increase the hours. I've told them, I don't know about that. I do think your fine revenue for CE non-compliance would increase. I think the important thing, one of the things that you see, and I'm sure you guys all see this when you go through your CE, is some people occupy the chair while they're doing the CE, but they're not gaining anything from the education. And I think that's the bigger issue, is that education is meaningful. And it allows you to further your career in real estate. It's kind of meaningless if we're just subjecting you to go sit in a chair for 4 hours and we don't require you to learn something. So that is kind of what's going on with CE. That sunset, that's going to be the big project for the upcoming year. It does take a tremendous amount of work on our part and also the Office of Policy Research and Regulatory Reform that does the reviews. But what they'll do is they'll compile a bunch of data from us. They will analyze the issues. They will reach out to stakeholders to get, really the real estate community's assessment on real estate broker regulation. They'll prepare a report, and it will have recommendations about things that possibly should be changed. That report will come out on October 15th of next year. And then regardless of what the recommendations are, unless they say, no, the real estate brokers can self-regulate, there should be a bill that comes through in the 2017 legislative session, I would assume, to continue the regulation of continue the Real Estate Commission. They do a sunset review of the division as well at this time, and it kind of allows us to make some recommendations just on the broader scale of things that we might like to see changed, or they can make some suggestions on how to enhance division operations. So that's sunset. On the smaller scale, what we are dealing with the Real Estate Commission right now is forms still. So we had to change the commission meeting for this month. Apparently there's an NAR conference this week, and we weren't going to end up with a quorum of commissioners because several of them were going to be at the conference. So the commission meeting has been moved to December 7th, that's Monday. We will be discussing, they want a list of all of the commission-approved forms. At first, I thought they wanted to go through every single commission-approved form line by line, and I threatened to go find employment elsewhere. They just want to look at the list. So they'll be looking at the list of forms. We'll be doing forms committee appointments. And I have gotten like a handful of people that are interested in being on the forms committee, and I'm going to recommend that they do put some new blood on the forms committee. It's been around for quite a while, and it's always good to have kind of a fresh perspective added to it. One of the things that's come up is at an earlier commission meeting, I want to say it was in August, they said we want a 3-year moratorium on forms changes. So we just came out of a 2-year moratorium. So when you tell me 3-year moratorium, we went through 2 years with no forms changes. To me, it means 3 years, no changes. But then they said, well, each form will have a 3-year limit. And this is the part that's gotten confusing. So we have some that seem to think, well, we're going to have changes every year, but then the 3-year moratorium will just apply to specific forms. And I don't think that was the reasoning behind the 3-year moratorium. I think kind of overwhelmingly the message that we've gotten from the brokerage community is you have liked the 2-year reprieve from the constant forms changes. It's allowed you to really get a grasp on the changes that occur with those forms and kind of master that primary tool that you all use in your day-to-day business. So There's the one camp that thinks, okay, we're going to continue to draft every year, but it's a 3-year limit per form. And then there's those of us, and I fall into this category, that think, no, you said 3 years, it means 3 years, no changes. So we will be discussing that. There's also an issue that came up with the contract to buy and sell. It's section 2.5.1. We had taken out a heading that has created some issues. So we are going to discuss putting the heading back in. So that'll be a last minute change to the contract to buy and sell for January 1st of 2016. But that is the only provision on that contract that they will be discussing, because that is the only provision I put down on their agenda. So that's forms. We did put together a global list. There were about 25 recommendations that had been made via email, either to the global list email box or to me. We vetted those through the forms committee, and then we will take them along to the Real Estate Commission to make the final decision. I will tell you, so whatever they decide on the moratorium, as far as, is it going to be 3 years, no changes, or is it just restricted to the individual forms? They did set up some criteria, and we will be discussing this. I drafted a document for the commission's review on Monday, because they said they weren't going to make any changes to the forms when there's a moratorium in place unless there was a legislative change, there was a case law decision that came out that affected the forms, or if the Attorney General's office, who's the counsel for the Real Estate Commission, identifies kind of a critical error in the forms. Then those are the 3 premises under which we will change the forms outside of the 3-year moratorium. So I have memorialized that in a document that has gone to the commission, and we will discuss on Monday. It also sets up roles and responsibilities for the 3 entities, and the 3 entities are, the Real Estate Commission is the ultimate decision maker on those forms, but they have really kind of delegated to the forms committee to do the drafting and really manage the bulk of the workload. And then you've got the real estate, the division of real estate that manages the administration of the commission, also the administration of the forms committee, and at the end of the day, we are the keeper of the forms. So it kind of lays out those roles and responsibilities, because we've had some growing pains over the past year or two when we changed the forms process about who does what, and I think there's been some struggles about, we've got a couple commissioners that try to draft language during the meetings, which frustrates other commissioners, and then you've got the forms committee that from time to time, the level of criticism makes them want to run away. So I'm hoping that we'll get everything forms related kind of hashed out at Monday's meeting, and then if they decide to make the change to section 2.5.1, we will send out an email blast to let everybody know, and we will do our best to get a hold of the different forms publishers so that they're aware that this change is coming for January 1st. So that's kind of the big project for the Real Estate Commission. They are still working on the definition of a standard form. Another iteration of that definition draft will go in front of them in February. This has been kind of a long process, and I'm not exactly sure when you can anticipate rulemaking, but once they get to a place where they're happy with that definition, we will file with Secretary of State the F7 rule, which is the one that they're proposing to change. We're also going to do cleanup on the other F rules to make them really more consistent with each other and hopefully easier for you guys to use. I think when I came to the division, I did not have a working knowledge of all of those rules. I remember when I was in broker school, it's like, okay, you're going to need this book to pass the test, and then you won't ever need it again, which I thought it was a little weird because I was a police officer at that time, and I'm like, wow, the book's got like statutes and rules in it. And those just don't go away once you pass a test. But I think that's kind of the common mantra that's given to a lot of the real estate students. So they don't have this working knowledge of all these rules. But I think you guys have some, like the E-rules are the enforcement ones. Those are the ones that will get you into hot water most of the time with the Real Estate Commission. So I think to some extent, a lot of the actual practicing brokers, the ones that are not doing it as a hobby, are aware that there's the E-rules, and you kind of got to watch those. The F rules, I think a lot of the time are lost on people. It's just like, well, I'm not an attorney, I can't draft my own contract. I'm not really sure where it says that. There's the commission approved form. So hopefully these will be a little more valuable to you once we go through the rulemaking process. That's the real estate commission. So we have multiple other programs, as Greg told you, at the division. Another big one that we've got going on right now is we are under audit for the conservation easement program. This is an audit that we requested. It's an update from our 2012 performance audit performed by the Office of the State Auditor. Back in 2012, the auditor looked at Division of Real Estate's portion of the conservation easement program, and they looked at Department of Revenue's portion of the conservation easement program. And they'd made some recommendations, and the agencies both committed to implementing those recommendations. But overall, kind of the gist of it was, back in 2012, we did a lot of consulting with Revenue on the cases that they were looking at, trying to determine whether they should deny it or not. And some of the time they'd already made the decision to deny it, and they asked us for consultation. We would get the appraisals in just based on another statute, and we'd kind of look at those, but it wasn't as robust of a program as they expected it to be. And that was kind of one of the things that they said was that real estate, you need to do a little more scrutiny on those appraisals when they come through. We're expecting a more arduous desk audit to be done. Revenue, when they were looking at the transactions, they were doing substantial compliance with the different regulations. And the state auditor really said, no, you shouldn't be doing substantial, you should be doing strict compliance. But overall, one of the big recommendations that came out of that audit is they wanted the two agencies to work together to figure out a new process for these transactions to go through so that the landowners donating these easements would have some sense of security that once they did the donation and they sought to use their tax credit, that government wasn't going to come back and yank that tax credit away, and then suddenly they're responsible for penalties and interest to the government because their tax credit's been denied. So we ended up with this new program, or this modified program in real estate. We examine the transactions for conservation purpose, and we also look at the appraisals. And I will say we've gotten a lot of criticism about the level of scrutiny that we put those appraisals under, because in 2014, there were 35 applications submitted for this program. 89% of the appraisals submitted had deficiencies. And of the 35, 10, and we have been working through the deficiencies in a couple different ways. If they're not horribly frightening, we will work with the appraiser to address the deficiencies and move on that way. If you've got some really, really significant deficiencies, then we have to issue a notice of potential deficiency to the landowner to set them on notice that this has got to be fixed. So of the 35, 10 of those fell into that category of these have got to be fixed. These are critical. At the end of the day, and these are really involved reviews, both on the conservation purpose side and the appraisal side. So of the 35 that were submitted in 2014, 33 of them have been issued. We have not denied anything yet. We have 2 pending ones because they had those issues. Some of them had such significant issues that me as the division director felt that I would be failing to perform my duties as a public servant if I did not refer that appraiser over to the Board of Real Estate Appraisers for investigation. You got to figure out these appraisals, from what I'm hearing, are costing landowners $25,000, $30,000. If you're going to pay $25,000, they should appraise the right property. Or deal with some significant property characteristics that would affect value. So those, because of the criticism and everything else, and we'd also like to have some assurance of, are we implementing this program in the manner that you anticipated when you made the recommendation back in 2012? The executive director of DORA back in May had asked for the auditors to come back and do an updated audit. So we've asked for 3 things in particular. One was that we asked that they look at how we addressed their concerns about conflicts of interest with that commission. We've asked them to look at the review process and to see if that is what they anticipated, if that was the intent of the law change. And then lastly, we asked them to look at the funding mechanism for that program because it has never been appropriately funded in real estate, and we've always been operating on a skeleton crew. And so along with criticisms that we've got about the extent of the appraisal reviews, we're also getting criticized about how long they take. The program's supposed to have 3.5 full-time employees. It has been operating with 1.5 FTE because we get screamed at over the fees that they have to pay. So that is the other big project. It's anticipated that that may take about a year also. So those are going to, sunset review for the Real Estate Commission and the audit for the Conservation Easement Program are going to be the two big projects that we're facing in 2016. And if nobody runs legislation that like grossly affects real estate, I will be really happy, or at least division of real estate. I know that CMLA is anticipating running a bill to really kind of harmonize federal and state law. We have pointed out to them, I don't think it's very fair that if you look at the Mortgage Broker Practice Act, there are 2 sections where if you do something wrong, you can be penalized in 2 different areas. It's got 2 kind of professional standards sections. So I'm hoping that they kind of merge those into one so that it's not fair that if you make one mistake, you can get kind of dinged from 2 different angles. There are some other things that they're cleaning up. And to date, you know, what we've discussed, we haven't had any issues with, but I haven't seen the recent draft of it, so I can't say officially whether it's okay or not, and I wouldn't be able to do that anyhow. That's a DORA determination. But I do know that mortgage is coming up for us. Aside from that, for the mortgage program, we will be implementing the uniform state test for them on January 1st. That'll come into play. That should help really with the portability of those licenses across different states. A lot of the mortgage loan originators licensed in Colorado, like 60% of them are actually located out of state, and the uniform state test has been a big issue for them. The appraiser program, they had federal rules go into place in August regarding appraisal management companies. So one of the things that we need to do, we've got 3 years in which to implement those changes, and at a minimum, we are going to have to modify the Appraisal Management Company Practice Act because it's inconsistent with these rules. But one of the things that will be facing the Board of Real Estate Appraisers is the decision on whether we continue to regulate appraisal management companies or not. I know they were a huge bane of existence before they were regulated, but now that they've been regulated, it's gone really quiet for the most part. I mean, I think we've actually gotten one complaint where we may have jurisdiction over their activities. It's fallen silent, and if we choose not to regulate them, all of the ones that wouldn't fit the federal exemption for licensure wouldn't be allowed to practice in Colorado anyhow. So that is one of the things that we're looking at with the Board of Real Estate Appraisers. Otherwise, we try not to mess with BREA too much. That's what we call them, Board of Real Estate Appraisers. They went through a sunset review back in 2012. There was an error with the bill that was run. They forgot to reset the sunset date. So we actually went into wind down. And so when we ran a bill to continue the Board of Real Estate Appraisers, then it's like, well, you know, some of our legislatures don't like to hear about federal mandates. So there was the concern of, well, we're just not going to pass this. The broader implications of if appraiser regulation were to go away, you would not have, your customers would not have any access to federally related mortgages. Existing FHA loans would go away as well. So it's kind of like the atomic bomb for the real estate industry is to have appraiser regulation get messed with. So we typically try not to mess with them. Community association manager regulation went into play July 1st of this year. I think as of today, we probably have about 130 complaints that have been filed against the community association managers. There's a lot of things that, you know, have been submitted to us that we don't have jurisdiction over. Unfortunately, I think there are some individuals out there perpetuating this message of just file it with the division, they can take care of it. We cannot cap transfer fees. It's a division director model program, but really at the end of the day, capping fees for a service, I believe, is a legislative mandate, not something for me to decide. And I think that would be a horrible precedent if I were to say, okay, you can only charge up to X for a management fee or a transfer fee, because I think that would ripple across the other programs. You'd start to have people complaining about, you know, this is ridiculous that I got to pay 6% for a real estate broker commission. Then they would want to see your commissions capped, appraisal fees capped. And there's just too much variation in the services provided. I mean, you would not charge the same for a commercial appraisal as you would a standard residential appraisal. So that's not a precedent I'm going to set. But some of the complaints that we're seeing have been generated because there's been some bad information floating out there. And we have tried to correct the information going along. But if you start hearing anything about file complaints with the division about the transfer fee, they can get your restitution. I do not have the authority under the Community Association Manager Program to order restitution. We also hear about neighbor fights. That's not us. That's the police department. Dog issues, primarily bodily function issues, is a leading driver of complaints for that program. We don't regulate that, so I do have to do a report to the legislature that's due in February. I think it's February 15th, just about the implementation of that program and recommendations that I would make. And we have kind of an ongoing list. One of the concerns I've heard about recently is that if you file a complaint against your community association manager, and we call them CAMs for brevity, you file a complaint against your CAM, there's, in that HOA management contract, they can seek financial recourse for legal matters. So they are starting to do that with people that have filed a complaint. They are then using that provision to say, well, if you're going to file a complaint against me, it's going to cost you. So that may be something that we ask the legislature to consider. But that's Community Association Manager Program. There's not been anything really exciting going on with it. We've got our noses to the grindstone working on the investigations. We are working on one case that may end up being the first surrender of a license equivalent to a revocation, but he's been kind of non-responsive lately. He was talking to us and now he's not, so he may end up being our first summary suspension. But with that, that's kind of the division in a nutshell. I think I've covered most of the programs. Well, thank you for your time.